You too. Bye-bye.
Thank you. The next matter we have on for calendar is Zorab Siskarides versus Irina Camp, case number A-23-867845-C. If I could have the parties state their names and appearances for the record, starting first with plaintiff or plaintiff's counsel, followed by defendant or defendant's counsel. And please include your bar numbers if applicable. We'll start first with plaintiff's side. Mr. Verchio, are you here for this matter? Who's checked in on this matter?
Hello?
Hello? Mr. Verchio? Is he checked in for plaintiffs?
Yes, he is.
Okay, we've lost his video now.
You're
Mr.
You're on,
Verchio?
I am here.
We can't see you.
Okay, I'll be right there. Can you hear me though?
I can hear you. Your bandwidth is low. Okay, we can see you now, Mr. Verchio.
Okay. Sorry, I'm sitting outside the other courtroom on the calendar call.
Okay, gotcha. All right, so we
right.
have Mr. Verchio for the plaintiffs, and what is your bar number, please?
1087.
Okay. And for the defendants?
Hello, my name is Alexander Boftovich.
And hello, my name is Erin.
And we're
Okay.
pro se.
All right, thank you. This is plaintiff's motion to compel discovery, impose sanctions and attorney's fees on an order shortening time. There was also a counter motion to dismiss the case, which is off calendar. I will not hear that. This is the improper forum to bring a motion to dismiss the case. And also, it is not a counter motion must relate to the underlying motion that's at issue, and the counter motion to dismiss does not relate to the motion to compel the discovery. Also, the motion for sanctions and fees for the wasted time on the fraudulent case, damages for emotional distress, damages for slander, and punitive damages. Those are all an improper counterclaim, so those will not be heard today. They are off calendar. If you want to bring that motion, it would have to be brought before the district court judge in a separate motion. It cannot be brought in a counter motion to a discovery motion that it doesn't relate to. Okay? So we will proceed only today with plaintiff's motion to compel discovery, impose sanctions, and attorney's fees on an order shortening time. I will turn the time over to Mr. Verchio.
Yes, Your Honor. I will. Sure. Problem is, we are now set for trial in June, and so the normal type of discovery order that might be forthcoming, allowing time. I don't know that that's going to be possible, given that we have a fixed trial date. Perhaps, however, the court could make findings with respect to the defendant's position. I mean, as the court has seen, there is no opposition. Setting aside the motion to dismiss, the motion for emotional distress, etc., there's no substantive response to our motion. That is, why has there not been a response to discovery? Why were there no appearances for deposition? And in part, it's answered by the defendant's own pleadings, wherein they have stated, we are not going to participate in this corrupt, fraudulent proceeding. That's been essentially their substantive position. So based upon that, I believe, rather than saying, well, we'll give them 10 days to appear or 5 days to appear, I think it's just appropriate to make a determination that the defendants have self-declared an unwillingness to participate.
Okay. All right, thank you. Ms. Camp and, well, I'll just turn the time over to the defendants. I don't know who's going to speak on behalf of you, but I guess you each can speak on behalf of yourself. You can't speak for each other because you don't represent each other, so you'll each need to make your own appearance.
Okay, may I have just few minutes to explain some situation, what's going on here. I'm sorry for my English and my hard accent, but I will try to do my best.
That's fine.
Thank you. So I have my exhibit about conspiracy activities. Mr. Verchio convinces the respected court that my son and I are groundlessly slandering people after watching enough TV. This is not our invention, but facts, and we have documents prove it. The story began 2 years ago, and the case began considering in court is part of it. Just few minutes I will explain, if it's possible. Thank you very much. When 2 years ago, one of 3 HOAs published a financial statement about its activities, we noticed that management salaries suddenly increased by 2-3 times, office rent by 2-3 times, various expenses what had not documents, and deceased employee and bank statements. Money for all this was taken from the reserve fund, which gradually disappeared, confirmed by documents. We started writing HOA to the management of the company, but did not receive an answer to our question. The same HOA was noted in court as illegally taking away homes from residents. There is a fact confirmed in a writing by HOA itself. This year, 2 million reserve fund was completely gone, with a remaining balance of $0. Illegally demands an additional $30,000 from each resident to cover the money stolen by management. The monthly payment now increased to $1,000 per month. This is fact. In February-March 2024, the criminal activities of HOA were discussed between the residents. We have document. Dissatisfaction of residents group of 20-30 people demands to remove the company's management and thoughts on what to do with all this next. There is correspondence. A meeting where the president of company in front of 150 people confirmed that the boat, Zurab's boat, that had disappeared from the pier belonging to the house at Via Mantova, Unit 2, was with him, and when he might someday return it. This is also, we have audio recording. Refusal of police to take a report about this accident, as well as other reports about the disappearance of the boat. However, they were still made by police with a delay of 2 months after the events, but no investigation were undertaken. And I received last week letter from attorney office about investigation into theft of the boat, but no answer until today. And last week I received letter from President Charles' lawyers threatening me and my son to take away our house and put us in a prison. And now, last minute, please give me this your attention. Now question to Mr. Varikio. Why did HOA management, Henderson police, who were found guilty in wrongdoing, suddenly became clients of Mr. Varikio and participate in this case? What did Judge Gloria Sturm pay attention to at the first hearing? Why did Varikio come to their defense and demand that all information about their criminal action be erased? How many clients does the Varikio have in this case, including Zurab, Henderson police, Zurab's ex-wife Alexandra Costa, and HOA management? Who pays for a case that has been going for 1 year? Mr. Zurab has a pension of $2,000 and it's clearly not enough. Mr. Varikio still has not explained until today to the court and judge the mortgage of someone else's house in this case with help of company. Name company is June's Legal Service. Fake service using for the same company. Payment fee in our name with our son, my name and my son. Varikio's own admission that he did not create this case but only filed private contact with a commission agent without publication in court. And I believe Mr. Varikio using our constitution for his dirty games. It's why I was refusing to participate in this case. Thank you very much for attention.
Thank you. Anything that you would like to say, Mr. Bogdovich?
I would just like to basically go over a few things, and the first one is the fees, disclosure of fees filed in this case. It states that me and my mother are his clients, and that he paid $300 to start a new case, which is not true. I don't know what's the purpose of that document. The next one is being the list pendants, which was fraudulently filed and recorded. It had the correct address, but it had the wrong parcel number. When we found this out and sent a letter to those homeowners, only then did Mr. Varicchio remove the wrong list pendants. But there's still no list pendants for the correct house, which is based on the law. To get one, he has to bring a verified complaint with the signature of the plaintiff, which we have been trying to find for the longest time, but he still has not showed it. And just like he said during the last hearing with Judge Sturman, he because the complaint is written on the 24th, and during the hearing he stated it certainly was not written on the 24th. I only filed it on the 24th. So there's so many issues going on in here. Same with the fake fraudulent service. I will just say one example of this issue. The affidavit of attempts of service. The very first one, it says that the service person went through the back gate, knocked and rang bell, and there was no answer. The issue is our house has no back gate. There's a solid wall. There's no bell in the back. So this service was not attempted at the residence where we were living. And Mr. Varicchio has failed to answer any of these questions and continues to slander us and continues to decide what is fact, what is not fact, without letting the court hear those things. Thank you.
Okay, well, let me explain that why we're here today. We're here today because Mr. Varicchio, on behalf of his client, has filed a motion to compel discovery and to impose sanctions and attorney's fees on an order shortening time, requesting that your client or that you provide responses to the discovery. For example, the written discovery responses were due on February 8th, 2024. And Mr. Varicchio, can you just state what those responses were, what discovery was sent that was due on February 8th, 2024?
It should have been request for production of documents.
Okay, were there any interrogatories as well, or was it just request for production of documents?
I believe it was request for production.
We're losing your signal. You had a better signal back where you were.
You're losing my signal?
Yes.
Okay, here? Okay.
What date was your motion filed in, that we're here on today? Let's see, just a second.
Okay.
I'm looking for it now, just a second.
It was...
I'm looking, their opposition filed on 4/15. Okay, it was on plaintiff's motion to compel was on 4/15 as well. That was when the order shortening time was filed. Okay, so let me just look at that just a second. Again.
So it was a request for production of documents. There were 2 depositions scheduled for the defendant.
Right, no, I knew we needed to get to the depositions, that I wasn't there yet. But the only written discovery was the request for production of documents?
Yes, and as well, the 16.1 production was never done by the defendants.
They've still never done that?
They have given a very strange links that I cannot open. They are links that are subject to be changed and require access of our computers to links that are jeopardize the security of the computer.
Okay. All right. So the discovery requests that were served, what day did you serve those on behalf of your client, Mr. Varicchio, the request for production of documents?
January 9th.
Okay. So they were served on January 9th. And we are here today to talk about those, why there was no responses served to that. And we are also here to discuss why you have not provided documents as required by Nevada Rule of Civil Procedure 16.1. Also, there were deposition notices to both of you as defendants that were scheduling the depositions for March 14th and March 15th, for which neither appeared. And there was never a response to any of this requested discovery. That's what we're here for today. I understand that you have issues with Mr. Verchio's clients and you believe that you've been wrongfully accused. I understand that from what you've presented here today, that you do not believe that there is evidence to support the allegations that they've made against you. However, you are required under the rules of civil procedure, when they serve you with written requests for discovery, to respond to them. In addition, when your deposition is noticed, and they don't have to serve you personally with a notice of deposition. If you are a party, they can merely mail it to you or e-serve it to you through the court website. You are required to appear for the deposition. And so I am going, and there was no opposition.
I'm sorry. Could I respond to those?
Just a second, I will give you a chance in a moment.
Okay.
I did not receive in your opposition, that was filed, let's see, on 4/15. Just a second, I'm looking at it now. You talk about Mr. Verchio's fraudulent actions. You talk about the case origin and the claims for damage. Nowhere in there do you oppose having to respond to the written discovery that was served or to appear for your deposition. So pursuant to EDCR 2.20E, you have failed to oppose those portions of the motion. And under EDCR, under the 8th Judicial District Court rules, if you fail to oppose a motion, it can be construed that the motion was meritorious and a consent to the granting of the same. So I will let you speak, Mr. Bogdanovic, but I will say that you have not objected to the written discovery in proper procedure. You have not appeared for your deposition, and so I'll let you respond. Go ahead.
Okay, first about the 16.1 conference. Based on the laws that I read, it's supposed to be scheduled within a month of getting the answer filed, which was scheduled 2-3 months afterwards.
Okay, you're still required to attend it.
I understand. We did attend.
And you're still required to submit the documents required under Rule 16.1. Your list of witnesses and your documents.
I understand. We did the list of witnesses and documents. We did attend the conference in August of last year. What happened during that conference, and we brought this to Judge Sturman's attention, Mr. Verchio was being unprofessional. He was calling himself an idiot, a bad lawyer. And these are not things I'm calling him. He was saying those things. We have an audio recording of that. He refused to produce any information about this case. He kept on.
Well, if you need to bring a motion to compel documents from him, that's separate. What we're talking about today is you are required to provide a list of witnesses and 16.1 documents in the proper form. I know you're representing yourselves, but you're still responsible for doing it in the proper form. And also, you're responsible for answering the written discovery within 30 days.
Okay,
and that was not done in this case.
And the last thing, I won't take any more of the court's time. The last thing about this order of the shortening time, as you said, it was filed on the 15th, but what I failed to see, where was the original request? There was no request filed. How did this order for shortening time, the motion for the shortening time, how was it received by whoever made the order? Because on the 15th, there was an order posted for this hearing, but beforehand, there's no request for this hearing. There's no official documentation filed in the courts.
Do you want to respond to that, Mr. Verchio? The order of shortening time, my office is signed the April 15th order shortening time, setting it for today. Do you need more time?
It was an ex parte application.
And what day was that? Okay, so was that filed or was it submitted?
It was submitted and the court filed it.
Okay.
There's no court filing.
Your Honor, you heard Ms. Camp say, and that is why we refuse to participate.
I understand.
Yeah.
I understand. I'm letting them finish, Mr. Verrocchio. Anything further you would like to say?
Yes,
Mr. Bogdanovich?
so that's the last part. It's like, so there was your office that assigned the order shortening time, but how did that office receive those documents? They were not filed.
They sent them ex parte.
So they were not filed in the courts. That's basically, no, it was not. And I'm saying that because I looked at the court things.
I'm looking at it. It's number 94. There's an order shortening time with with plaintiff's motion to attached. It's all filed.
Yeah, but
Plaintiff's
the motion was never filed.
It was filed.
Together with the order?
Document. It was filed as one document.
So that doesn't make sense.
That's how that's done.
Okay, so basically, you received private information from Mr. Verrocchio, which you made the order based off. And it also was not served to us. Not e-served, not any kind of served.
Was the application for order shortening time e-served, Mr. Verrocchio?
No, it was done in one document and it was uploaded. And again, we are on this criminal conspiracy that this gentleman, insists on.
So it was not served, and I would please ask you to stop calling me criminal.
It was served on 4/15.
It was not e-served to us.
He responded to it.
I did, but it was not served.
Again, this is the pro per ignorance that they insist on refusing to accept any type of assistance of a legal nature.
I would like to ask.
Let me just say that the documents that were served to you, the request for production of documents were due on February 8th. You failed to respond to those. Those will be due within 1 week from today, no later than May 9th. In addition, you are both required to sit for your deposition within 14 days from today or no later than May 16th.
I repeat, we will not continue participating in this fraudulent case. He can win. Good luck. We defaulted. We're done with this fraudulent case. Thank you very much.
Okay, well, I understand that's your position, and if you don't appear for your deposition, then Mr. Verrocchio will take the appropriate steps that he's entitled to. But I'm just saying that he can reset the deposition today on shortened notice. Mm-hmm. You must sit for your depositions no later than May 16th in this matter, and the discovery is due no later than May 9th. If you fail to comply with this court's recommendation, that's your choice, but that's what the court's recommendation is going to be. So the motion to compel is granted. The plaintiffs must submit their 16.1 disclosures and their response to the request for production of documents that were served on May 9th, 2024, no later than May 9th, 2024. They must sit for their depositions no later than May 16th, and they are to respond to Mr. Verrocchio as to which days they are available for their deposition in that period of time. If they do not appear for the depositions, he may take notice of non-appearance and then may move forward with what other further action he seeks to take. In addition, I will grant attorney's fees as sanctions against the defendants. I will only grant the amount for the drafting of the motion, the review of the opposition, and there was no reply, so I will not grant anything for the reply, obviously, and for the appearance here in court today of 45 minutes. So, Mr. Verrocchio, I'd ask that you prepare an affidavit that addresses the factors set forth in Brunzell versus Golden Gate, along with an itemized listing of the time spent in drafting the motion only, reviewing the opposition, and appearing in court here today for 45 minutes. That will be due to me within 14 days. I will set this for a status check hearing on June 6th at 9 a.m. At that time, I will make a determination as to the amount of attorney's fees that will be imposed against the defendants for their failure to participate in discovery. In addition, I would ask Mr. Verrocchio that you prepare the report and recommendation from today's hearing, noting that the counter motion to dismiss and for sanctions is off calendar as filed improperly. I would ask that you address the recommendations that the court has made here in the report, in the Discovery Commissioner's report and recommendations. Send a copy to Ms. Camp and Mr. Baktovich and give them a chance to respond regarding